Hotel Liability for Guest Property from Common Law Through Today by Alexandria Gillette. Hotels and inns have been around forever. Their laws started out non-existent, then grew into rules, eventually evolving into the laws that we have today. Liability is defined by LAW.com as, quote, legal responsibility for one's actions or omissions, end quote. This responsibility has fluctuated and changed over the years until we reach what we have today, though our laws are still ever-changing. We have become very accustomed to being liable for our own possessions due to the state of our law now. However, it has not always been this way. Beginning with the first real laws on this topic within common law, a prominent case can be noted. In 1345, Bobeck v. Waltham established a precedent for many, many years to come. According to History of Innkeepers' Law, quote, William Bobeck brought a suit against John of Waltham, an innkeeper, with the complaint that his belongings were stolen from his room. The importance of this case was vital to the future of innkeepers' laws because it helped establish a duty of care for the innkeepers for the guests' goods when they are accepted by the innkeeper for safekeeping and they are aware of the location of the goods. The statement in the suit brought by Bobeck, which would resonate in the centuries to come, is that every innkeeper is bound to answer to his guests for goods placed under his control, end quote. This precedent was still in effect centuries later in 1896. According to Washington State Hospitality Law Manual, written by Irvin Sandman, quote, under English common law, an innkeeper was deemed responsible for the full value of any property of a guest or visitor, end quote. This became a precedent after the court ruled it so in the Cunningham v. Buckey case in 1896. Early liability for hotels and innkeepers was very broad, and some might say unfair for hotels. At this point, if someone staying in an inn were to have their $500 necklace stolen from their room or bag, the innkeeper would be liable for the full value of it. This was attributed as defect of the guard due to the fact that the person who was robbed was under the care of the innkeeper at the time. Under English common law, liability rested heavily upon the innkeeper. Innkeepers were liable for theft of guest property in most circumstances, unless previous notice was given otherwise. In today's day, that had changed quite a bit. In 1909, the case of Walt v. Kilbury brought about a new incentive. According to Sandman, quote, the Washington State Supreme Court approved 3 exceptions to an innkeeper's common law liability of an insurer. The court ruled that an innkeeper is the insurer of the property of his guest, and liable for its loss from any cause unless such loss comes from 1. An act of God, 2. The public enemy, or 3. From the neglect of the guest himself, end quote. These 3 exceptions were the ones that innkeepers were able to defer to for 6 years, until the trend of loosening innkeeper liability caught on. In 1915, the new statute RCW 1948 was passed, which tremendously changed how the public was to view hotel liability. Within RCW 1948, quote, the statute provides a safe harbor that eliminates liability to guests for loss of these valuables in most cases. To qualify, the hotel must take 2 steps. First, the hotel must provide a safe or a vault for the safekeeping of these valuables. And second, the hotel must give guests actual notice of the availability of the safe or vault by posting a notice in 3 or more public and conspicuous areas, such as the office, elevators, public rooms, or lobbies, end quote. With these 2 steps taken, the hotel is a safe harbor and cannot be liable for the loss of a guest's valuables in most cases if they do not deposit them into the advertised safe. Also in RCW 1948, the hotel itself is no longer liable for the deposited valuables into the vault. Unless, in fact, they are lost due to the negligence of the hotel. And if they are to be liable, the liability in this instance is no more than $1,000. The statutes in RCW 1948 are still in effect today and have a huge impact on the hospitality industry and liability for guest property. These laws are to protect every party involved, and they are a good thing for the hotel industry. For a guest, this means that they must be more responsible with their belongings. For a hotel, this means that they will not be liable for something they can't control. Without these laws, liability would not be outlined as clearly and would make for longer lawsuits and larger gray areas when it comes to laws surrounding hotels. These changes help hotels flourish and maintain good hotel and guest relationships for years to come.